He testified that the accused did not look like the person who appeared on the photograph which was sent to him. The accused asked him to remove his shirt and pants and to lie on the massage table. The accused started to massage him from his ankles up to his calf area, and from there to his thighs and buttocks. The accused then got on top of him whilst having an erection. He then rubbed his penis against SJ's anus. SJ said no to the accused. However, the accused continued and did not listen to him. He inserted his penis into SJ's anus. SJ testified that he cringed and he surrendered. The accused penetrated him and the pain was excruciating. Please leave your hands down. This is the time for you to sit and listen.
May I please sit?
If that is what you want, you are entitled to be seated.
Thank you.
The accused was not wearing a condom. The accused said to him that he has a client for him who would arrive at 8 p.m. Excuse me. He had to massage the client and play with the client's, in inverted commas, dolly, close inverted commas. When the client arrived, AJ started to massage the client. The accused went outside, and he learned later that the accused peeped through the window and observed him whilst he was busy with the client. The accused started to act funny towards him, that is SJ. He told SJ that he liked him a lot and that he was very beautiful, and that what he saw really upset him. The accused said to him that Kennedy wanted Jaden and him to go to PK's house. He said Kennedy would love him because he had, in inverted commas, a Busman gat, close inverted commas. An Uber vehicle came to fetch them, and they were taken to Kennedy's residence. At Kennedy's place, he took them to the lapa where they were offered soft drinks whilst they chatted generally. They then went to Kennedy's bedroom where he took off his clothes. They were in the bathroom where they undressed. They then went to Kennedy's bed and the three of them were naked. They started massaging Kennedy and he started touching them on his leg and his bum. Jaden and SJ also started touching each other. Kennedy then gave them, in inverted commas, a ring job. That is, he licked his anus. Thereafter, Kennedy asked Jaden to penetrate him. When they reached accused place, Jaden and the accused were arguing about money. That night, the accused wanted to sleep with Jaden. However, the two boys slept on the couch. SJ met TW on WhatsApp. Gerry said to him that this man is going to work with us and that he was going to be massaging with him. During cross-examination, he said that he was 16 years old when he went to the accused place. It was put to him that the sexual intercourse that the accused had with him was with his consent. SJ replied, no, he did not consent. He was asked what else apart from the clinching did he do, to which he replied that he did not want to be penetrated. Heading, TC's evidence. It's 30. TC, like the other boys, met the accused on Facebook. He was 15 years old at the time. The accused inquired from him whether he was interested in obtaining work, and the boy told him, and he told the boy about his massaging and cookies business. He told the boy that he operated this massaging business from his home. He told him that he could earn 700 Rand per hour. Accused agreed to buy him a bus ticket to get to his place. The accused requested that he should send him photographs which he needed to send to his boss. TC told the accused what his age was. The accused told him to make a video where he was taking off his uniform. Such a video was made and sent to the accused. The accused insisted that the minor make a video where he would be naked. Such a video was made by the boy on TikTok. He did not receive any compensation for making the video. He was prevented from going to the accused place by his mother, and he never met the accused personally. The boy was subsequently contacted by Warrant Officer Duplessis, who eventually took a statement from him. During cross-examination, he stated that he sent 7 photos to the accused, including video recording. 14. Evidence of RR. He testified that during 2009 he was 9 years old. His family was spending their holidays at Hartenbos. He and his cousin went to the shower facility for campus in order to shower. Whilst they were showering, they were playing a game where they threw their shorts over the cubicle towards a wooden structure. One of the trousers stuck to a pole and got stuck. When they tried to retrieve the trousers, they saw a man walking around the shower facility naked. According to the witness, it was unusual for a person to be walking around. People would cover themselves, which would be wrapped around their waist. This man had an erection. They felt uncomfortable and decided to leave the ablution facility. RR returned to their camping site and reported the incident to his uncle. His uncle went to confront the man. 2 years later, during 2009, he was once again with his cousin at the ablution facility when they saw the man again. His cousin told him the man is back, and he was once again crawling around naked. It was put to the witness that the accused would deny that he was there in 2007. However, he would admit that he was there in 2009. 15. DR gave evidence that he was with RR, his cousin, during the two incidents. The witness confirmed the evidence of RR. During cross-examination, it was put to him that the accused would deny that he was there in 2007, and the witness replied that he can say with 100% certainty that he, the accused, was there in 2007. 16. DR Senior, that is the father of DR, testified. He testified that the report was made to him in 2007 by his son and nephew regarding a man naked with an erection. He saw this man walking from one bathroom to another bathroom, which was approximately 200 meters apart. This man entered the bathrooms on at least 2 separate occasions whilst he observed him. He eventually grabbed the man by his t-shirt and pointed a finger in his face and told him, in Afrikaans and in inverted commas, "For jou gaan ek bliksem," closing inverted commas. The man told him that he has such problems and he would not completely understand him. A photograph of this man was taken from behind. See Exhibit D. He pointed out the man to be the accused seated in court. He saw the accused again during 2009. He was adamant that it was the same person he confronted 2 years prior to this incident. He followed the accused for some distance on the beach. The accused climbed some steps leading towards the road, and eventually he lost sight of him amongst the houses. The witness's wife phoned him to inform him that the police arrested the person. When he got there, the accused was in the back of the police vehicle. 17. Evidence of DLD. This witness met the accused on the app called Grindr. He was 16 years old at the stage. The boy gave him a WhatsApp number which belonged to the accused. He was told he could perform massages for money. He was desperately in need of money. He arranged to meet the accused. He got into an Uber and was transported to the accused's place. Like the other boys, the accused told DLD to lie naked on the massage table and started massaging him. The accused then explained that he should repeat his actions on him, the accused. The accused was wearing a shirt at that stage. The accused turned around and removed his shorts. He then asked DLD to touch his penis. The boy was hesitant as he did not expect this. However, the accused told him that he did inform him that he would have to fondle people's private parts. He fondled the accused's penis until he ejaculated. The accused climbed on top of him and placed his penis between, in inverted commas, his cheek and his bum, and then shoved his penis into his anus. Close brackets. He cried out in pain and then ran to the bathroom. There was blood on his penis. He decided to get his stuff and get out of there. The accused apologized and asked him to stay. He phoned one of his friends to fetch him in order to get home. He did not tell his friend what happened. He wanted to forget about the incident and he pretended it never happened. During cross-examination, it was put to DLD that the accused sent him a photo, and DLD said that he liked the accused because he preferred, an inverted commas, jocks, close inverted commas. The witness responded that he did not recall that. He was asked, when you touched the accused's penis, did you say anything? And he replied that he did not realize that the massaging business embraced the touching of penises. It was put to DLD that he was interested in having sex with the accused, to which the boy replied, I never wanted to engage in sexual activity with him. 18. Evidence of W.S. W.S. testified that he was told about Dante or Harry by Peter. He was 14 years old at the time. He made between 1 and 4 videos for the accused. In the videos, it was him, JP, and Dupe. Dupe recorded the video and they had to masturbate, which was recorded on the video. Footage was taken of their private parts and buttocks, but not their faces. He was paid money for these videos. The videos were sent to Herman, who in turn sent them to Harry. They received payment by means of e-wallet from the accused. They were taken to the accused's home by Herman. Harry and Herman explained to the three of them what was going to happen. They were told that they would get 950 rand per massage. The accused taught them how to massage other men, and they had to rub the client's private parts. Harry fondled his penis, and he in turn did the same to Harry. Harry then arranged 3 clients for him. 2 of the clients paid him 950 rand each. The third client was PK. PK gave him 4,000 rand. During cross-examination, he stated that he received payments for making videos from Peter. He was asked whether he discussed his age with the accused, and the witness answered that he did. It was also put to the witness that the accused prohibited sex on his premises, and WS replied in Afrikaans and in inverted commas, hy lieg, close inverted commas. During re-examination, he was asked, what did he tell Harry regarding his age? And he responded that he told him he was 14 years old. 19. WL's evidence. He testified that he and the previous witness were friends. William and Peter said that there was work to be done. They were taken to the accused premises by Herman. Once in the car, Herman touched him by his private parts, and he said he wanted to see what he was working with. He was 14 years old at the time. At the house, Herman gave them underwear to put on. They met the accused. Herman was undressed, and he laid naked on the massage table. WL, the witness, was shocked as he did not see anything like this before this in his life. They massaged him on different parts of his body. He was paid for making those videos. Those videos were sent to Peter. Paragraph 20. The incident at the Aquatic Center at Sunninghill. On this count, the witnesses Moses Molesani, Mike van Hill, AM, and AM's mother testified. Mr. Molesani, an employee at the center, went to the bathroom on the 23rd of June 2020 when he saw the accused at the urinal wearing a t-shirt and was naked from the waist down. He left the bathroom, and when he returned 20 minutes later, he saw the same man who was completely naked. This man was seated, and he had a phone in his one hand, and he was playing with his penis with the other hand. It was a weekday, and at that time the place was frequented predominantly by school children. This man's cellular phone was on, and he was taking a video. The rules at the place was that no photos or videos could be taken in the bathroom area. This man put on his clothes when he observed the witness, and he started to leave the bathroom. The witness approached his supervisor, Mike van Hill, and asked the man his name, and the man responded and said that his name was Harry van Zyl. He then saw the man walking to the cars while Mike was talking to one of the parents. The man got into his car and drove through the boom gate, causing damage to it. Mr. Von Hill received a call from a person later who told him that he was the person who damaged the boom gate and that he was prepared to pay for the damages he caused. He then told him that his name was Ackerman. Prior to the stranger driving off, Mr. Von Hill received a complaint from a distraught mother regarding a report which her son had made to her. The mother said that her son A.M. reported that the man was naked in the bathroom and that he had an erection. A.M. testified and confirmed that the man was naked and that he had an erection whilst in the change room. Para 21. A report from Mr. Marudidi Murundani from the Film and Publication Board, in brackets FPB, close bracket, was handed in by agreement. The defense had no objection to the contents of the report. In essence, the report stated, 1, that 664 picture images were found, which were found on the accused's cellular phone, contained child pornography. 2, on an Acer laptop, 1,310 images of toddlers between the ages of 6 to 12 contain images of these toddlers, penises, and several images of these toddlers being penetrated by having anal sex. There were some photos of these toddlers sucking male penises. This report was handed in as an exhibit marked G. Para 22. Henry Duplessis testified that he was the investigating officer in this matter. He was referred to by the complainants as Dupy. He received a complaint from a minor, SJ, to the effect that the accused rented him out to adults to perform massages. The minor told him that he received money for performing these massages and that a portion of the proceeds he received had to be given to the accused. SJ provided him with the cellular phone number of other boys who were going to perform massages for the accused. The witness made contact with TW and met him. TW told him that he came from Castell in the Free State. He took a statement from TW. He was told that PK paid for his bus ticket to Johannesburg. Ackerman told him to make videos and told him that the more revealing or sexy the videos were, the more money he would get for them. Mr. Duplessis applied for a J51 warrant to seize all the accused's electronic devices and storage devices. Armed with a warrant, he approached the accused. He explained his rights to the accused and handed him a copy of the seizure warrant. He requested that the accused hand over his cellular phones. The seizure warrant was handed in as an exhibit marked Exhibit H. The items seized were placed in sealed bags and they were subsequently handed over to Mr. Johan Claessens to download the devices which were seized. Mr. Kennedy was thereafter arrested. The witness testified that the accused told SJ that PK was HIV positive and that he should not engage in having sex with him. Exhibit K is a record of PK's HIV status. Exhibit M is the status of Ackerman's HIV status. And Exhibit P is a statement relating to SJ's HIV status. During cross-examination, it was put to the witness that the accused would deny that his rights were explained to him. He was asked whether he noted WS's statement. The witness confirmed that he did, and he was referred to paragraph 7 of WS's statement where the following is written. Ek was gevra by Dante om masserings te doen. Hy het nie aan my gevat nie. The witness replied that it was correct. Para 23. Thereafter, the accused made certain admissions in terms of Section 220 of the CPA. The amendments were read into the record and the admissions were also handed in as an exhibit marked Q. The Section 220 admissions contain 53 admissions, and I will refer to some of them hereunder. One, that on the 15th of October 2020, the South African police obtained a search warrant from Magistrate D.C. van den Berg of Johannesburg to search for and seize inter alia any computers and cellular telephones at the accused home at number 12 Wellington Avenue, Sandringham. Two, that an Asus laptop as well as a Huawei and Premio cellular telephones were seized during the above search. 3.4.6. The accused conducted a business as a massage parlor. 7. That Paul Kennedy played a role in recruiting / securing / bringing masseurs to work for the accused in his massage parlor. 8. The accused took a portion of the money paid to the masseurs trained by him. 9. That SJ was examined by the Far East Rand Hospital on the 6th of January 2022 by a registered nurse and that a J88 medical legal examination was conducted. The correctness in findings and opinions expressed in this medical legal report is admitted as Exhibit P. 10.11.17 that on the 6th of January 2022 SJ tested HIV positive, that is Exhibit S. 18.19 Paul Kennedy informed the accused of his HIV status on the 19th of September 2020. 20.21.22 that the sealed bag mentioned in paragraph 5 supra was handed to Mr. P.J. Claessens, a criminal investigator with the United States of America Homeland Security stationed at the Embassy of the United States of America, in Pretoria. 23. The contents of the statement of Mr. Claessens dated 4th of March 2021 under A22 in Sandringham Case 162/10/2020 is admitted and does not require further proof. See Exhibit T. 24. The contents of the statement of Mr. Claessens dated 21 September 2021 under A42 in Sandringham Case 162/10/2020 is admitted, does not require further proof. See Exhibit U. 25. 26. The folder contained extracts from cellular telephones and laptops of the accused is admitted as a true reflection of the information contained in these devices. See Exhibit X. '27. Mr. Claessens copied extracts of voice notes between the accused and Mr. Paul Kennedy to a disk, and it is admitted that the disk contained a true reflection of those conversations. See Exhibit Y. 28.29. That page 778 of the bundle referred to at 26 supra contains an excerpt of a voice note in brackets VN close brackets PWT/2020/10/WA0029.opus where the accused talks to a client and offers two boys, 16-year-old boys, including TW, and discusses what they will offer in payment. 31. 31. That page 779 of the bundle referred to at page para 26 supra contains an excerpt of a client, close bracket, open bracket, C, close bracket, asks the accused to find him a masseur who would, and in inverted commas, fuck, close inverted commas, him. 34. That page 111 of the bundle referred to at 26 supra contains an excerpt of a voice note to Paul Kennedy. PWT/2020/0819/WA0035.opus where the accused talk indicates that he is busy gaining a boy's trust. 35. That page 111 of the bundle referred to at 26 supra contains an excerpt of voice note PWT/2020/0819/WA0039.opus where the accused describes to Paul Kennedy how he is winning the boy's trust. 40. that page 1165 of the bundle referred to at 26, supra, contains an excerpt of voice note PTT 2020-0901/WA0083.opus, where the accused explains his strategy to Paul Kennedy. 41 ... 50 points 2 and 3 in Annexure A, referring to material extracted from the Huawei cellular telephones confiscated from the accused and included in Exhibit G, contains videos. Video /2019-1109/060320.MP4 VID /2019-1109/060223 which were both found in /DCIM/camera folder of the above phone. The videos depict the accused having sex with a 16-year-old boy, RB, with his consent. Para 24. Mr. Claessens testified that he was taken through some of the WhatsApp messages between the accused and Kennedy. SMS messages between the accused and his clients. These SMSs and WhatsApp messages were downloaded from the accused's phone, which was seized. The messages were compiled in 2 albums marked Y. The contents of these messages and WhatsApps appearing in the albums were not disputed. I do not propose to repeat the messages into this judgment as they are on record. Safe to state that some of these messages revealed how the accused offered the boys to his customers and others. He instructed the children how to make naked videos. The accused asked PK whether he preferred experienced, open brackets, boys, close brackets, or inexperienced boys. Fixing prices with his clients for services such as 1,200 for one and 2,000 for 2 boys. Para 25. Mr. Claessens testified about some of the messages contained in Exhibit Y, such as 1128 PTT 200826, where the accused is speaking to PK offering a child K, and 1149 2020 0821, where the accused is sending nudes to a boy, hoping the boy to do the same, and 1179 2020 0902, where the accused is asking PK, do you prefer experienced or inexperienced, namely boys. 26. The prosecution closed its case. Mr. Albert brought an application for the discharge of the accused in terms of Section 174 of the Criminal Procedure Act on counts 666 and 673, on the basis that no evidence was presented on these counts. The state did not oppose the application, and it conceded that no evidence was laid on these counts. The accused was consequently discharged on these 2 counts. 27. The accused, Mr. Ackerman's evidence. He was questioned about the incident at the Gama's Kloof in 2007. He denied that he was at the resort, as the 2 cousins testified. He admitted that he was there in 2009. He was walking on the beach and he needed to use the bathroom. He took a shower and he noticed the costumes were being thrown about. He saw the boys climbing up and looking at him. They were giggling. Thereafter, they left the bathroom. A man accused him of walking around naked in the bathroom with an erection. He denied this. He walked out of the bathroom and he was confronted by FJR Sr., who spoke to him about an incident 2 years prior to this incident. He continued walking on the beach and he noted that the man was following him and talking on the phone. He decided to hide away in order for this person to pass him so that he could continue on his journey to Mosselbaai. The mother of one of the boys came up to him and demanded to see his tattoos. He told her that he had no tattoos in the presence of the police, and he told them that they were confronting the wrong person. Regarding the incident at the swim school, he testified that he was living in Sandton and he wanted to swim. He Googled for swimming facilities in the area and found the place's address. He went there on the Friday. However, there was a gala taking place, He returned on Monday. Prior to going to the reception, he had an urgent need to use the toilet. So he went to the change rooms. Once in the change room, he started to get messages from clients. He spent time talking to his clients. Moses, in brackets Mr. Molisani, came in and he went to the locker. Both the child AM and Moses said that he was playing with his penis. Mr. Von Hill said that he must come to the office. He told Mr. Von Hill that his name was Gerhard. He was asked how he met TW. He responded that he met him on Facebook and they started to chat on WhatsApp. He said that he spoke to TW's father. He requested TW's father to make a TikTok video. PK was not happy with the video, so he gave him LV's video to guide him. He was paid for the video by Paul Kennedy. He stated that he trained TW. He testified that he trained SJ like the other boys. He admitted to having had sex with SJ. It was the only time that he had sex with SJ. According to him, SJ enjoyed the sex and he did not object to it. He testified that SJ also went to PK. WS and the two other boys were brought to him by Peter. The boys were told that they could make money if they made a strip video. The video was made which PK paid for. He met WS and WL for the first time when they came. Both of them said to him that they were 16 years old. According to him, Herman trained the boys in how to give a massage and as he went to play golf. According to him, WS had 4 to 6 clients. PK was one of WS's clients. The accused testified that he was contacted by Warrant Officer Duplessis who wanted to see him regarding his car. When he met Duplessis, he was told that he was trafficking children and that he groomed them to participate in sexual acts with third parties. He denied that his constitutional rights were explained to him. The accused stated that he trained them and they were willing to give happy endings. He also stated that his golden rule was that they were not to have any intercourse at his premises with clients. During cross-examination, he was asked what is rumming. He replied that when you use your tongue to lick around someone's anus. Mr. Ackerman denied that he instructed the boys to perform sexual acts, as his golden rule was that there was to be no sex. He was referred to voice note PTT 2020-01-WA031.opus, where a conversation between him and a client related to fixing a price for the boys' services. During the conversation, the accused stated that he has 2 boys, 1,200 for one boy and 2,000 for 2 boys. It was put to him that he was offering the boys to be rummed, BJ'd, and that he was fixing a price for the boys with his customers. The accused told PK in response to getting a boy this Friday that he must be patient. He has a strategy and that he is gaining the boys' trust. He admitted that he had anal sex with SJ and DLD. He was asked why did he break his own golden rule. The state advocate asked him whether he was testing the merchandise. He was questioned about the images which were found on his phone, and he testified that those videos were deleted and the authorities managed to retrieve them. He was told that it was in a WhatsApp file on his phone, and he then suggested that the boys had access to his phone and they must have uploaded it onto his phone. He had no idea of those images on his phone until he was confronted with them. It was put to him that those images were never deleted from his phone, as Mr. Claessens testified that he found them in a folder on his phone. He admitted that the boys made videos at his request and that PK paid for them. He was asked whether he directed the videos and he answered yes. Regarding the 2 incidents in the shower rooms at Dagamaskoor and Senton, he denied that he had an erection and he suggested that both Moses and AM were not speaking the truth. Heading: Evaluation of Evidence, paragraph 28. The following aspects of this matter are common cause. 1. That the accused met the majority of the complainants on Facebook and social media. 2, that the boys were taught how to massage potential clients of the accused and that they had to perform the happy ending on customers. 3, the accused arranged/made appointment for the boys to massage his clients and a fee would be charged for their services. 4, a percentage of the fee from the massages and or other sexual acts which the boys performed had to be paid to the accused. 5, the accused instructed the boys to make videos of themselves in a naked state, often playing with their penises. The boys were paid to make these videos by PK. The accused would direct and instruct them how to make these videos. 6, the accused clients, with the exception of PK, all came to the accused's apartment where the massages and or sexual acts was performed on them. 7, all the bookings for the massages were made by the accused for his clients. 8, the accused had anally penetrated 2 of the boys. 9, several of the boys lived with the accused at his premises where he operated his massage businesses from. Para 29. It is trite that in a criminal trial the onus is on the prosecution to prove its case against the accused beyond reasonable doubt. See R versus Difford, 1937 AD, R and R versus M, 1945 AD, as well as S versus Shabalala, judgment of the Supreme Court of Appeal. Furthermore, the court is duty-bound to consider all the evidence existing or presented during the trial. See S versus Van der Meyden, 1999, in brackets 1, SACR 447, in brackets W, at 449, J, small j, to 450, small b, where Nugent J, as it then was stated, open inverted commas, the proper test is that an accused is to be convicted if the evidence establishes guilt beyond reasonable doubt, comma, and the logical corollary is that he must be acquitted if it is reasonably possible that he might be innocent. The process of reasoning which is appropriate to the application of the test in any particular case will depend on the nature of the evidence which a court is before it. What must be borne in mind, comma, however, comma, is that the conclusion which is reached, open brackets, whether to convict or to acquit, close brackets, must account for all the evidence. Some of the evidence might be found to be false, semicolon. Some of it might be found to be unreliable, semicolon. And some of it might be found to be only possibly false or unreliable, semicolon. But none of it may be ignored, close quotation. Paragraph 30. In this matter, the children, by and large, were single witnesses regarding what happened to them. And for that reason, the court must view their versions with caution. Having said that, there are many aspects of their narratives which are similar to each other, such as how each of them was, in inverted commas, recruited, close inverted commas, by the accused, how he trained them to massage clients, that he made appointments for them to massage his clients, how the accused asked them to make videos, how he took a percentage of the fee they earned. 31. The court, in terms of Section 208 of the Criminal Procedure Act, may convict on the evidence of a single witness. See S versus Mokwena, 1932, OPD 79 at 80. In S versus Ackerman, 1968, Volume 3, SA, 339, in brackets, capital A, close brackets, at 341, capital B, Holmes J.A. stated, open inverted commas. Whilst there is always a need for caution in such cases, comma, the ultimate requirement is proof beyond reasonable doubt, semicolon. And courts must guard against their reasoning tending to become stifled by formalism. In other words, comma, the exercise of caution must not be allowed to displace the exercise of common sense, close quotation. CS versus Weber, 1971, Volume 3, SA 754, in brackets A, and S was Assault and Others, 1981, Volume 1, SA 172, capital A, at 180 alongside the letters E to G. Several children testified how they got to know the accused and how they were recruited by him, trained by him, and how they serviced his clients for reward. Most of these children did not know each other. However, the evidence has a pattern of similarity vis-a-vis the accused's recruitment, training, and payment they received from the clients, and how they had to pay the accused a portion of their fee. How he made appointments for the clients. In this regard, the state relied on S versus Mabata, 2018 ZAG PHC 502. Paragraph 32. When the evidence of each victim is viewed in isolation, the evidence must be viewed with caution regarding the minutiae of their testimony. However, when the evidence is viewed with other evidence in totality, one observes the common thread in their evidence. Ultimately, the test for the commonality in the evidence must be relevance of such similar evidence for the admissibility. As was succinctly stated by Schreiner J.A. in Matthews vs. S. 1960 in brackets 1, SA 752 at 758, that relevancy is based upon a blend of logic and experience lying outside the law. (33) I will now deal with the specific crimes the accused pleaded to. Counts 1 to 253 dealing with the video footage and images recovered from the Huawei Mate 10 Pro cellular phone, which was seized by Warrant Officer Duplessis. The evidence of Warrant Officer Duplessis, Muruledi, and Mr. Claessens is of pivotal importance on these counts. Their evidence was not disputed that the images which was found on the phone. On the contrary, the accused admitted that. Initially, his version was that it was deleted. However, the police managed to retrieve those images. Thereafter, he suggested that he did not download the images and that the boys must have done so, with the exception of the video recording him having consensual sex with a boy. His denial of taking these videos must be considered with the evidence of Moses Molasani at the swimming school, where he had a phone in his hand and that he was recording something. These two incidents are unrelated. However, is it a mere coincidence that he was in the change room naked as Michelangelo's David, save that he had a cellular phone as opposed to a sling recording the images on his phone? The accused's version regarding the images found on his phone was a denial by him that he was aware of them. So too is the incident of him recording in the cloakroom. His version on most aspects during the trial is a denial of what the state witnesses testified about, such as the incidents in 2007 and 2009 at Hartenbos, namely that the two boys and the father of one of the boys is mistaken about his identity at Hartenbos in 2007. I will revert to the accused's version of denial when I praise his evidence below. 34. The irresistible and logical inference is that the accused was aware of the images from his cellular phone. And in my view, he should be found guilty of these counts. The accused is accordingly convicted on counts 1 to 2, 3, 5. Paragraph 35, counts 254 to 639. Once again, the evidence of Warrant Officer Duplessis, Marudili, and Mr. Claessens is pivotal on these counts, which relate to the images found on the accused's laptop. The evidence was once again not disputed that the images were found on the laptop by Mr. Claessens, see Exhibit Y, and paragraph 28 supra. 36. The accused's version that the boys had access to his computer and they must have uploaded these images on his computer is far-fetched, and it ought to be rejected. One of the boys testified that they merely used his computer to listen to music. His version is not reasonably possibly true, as the accused admitted that his laptop had a password in order to gain access. Once again, his version is a denial that he uploaded his images, and he endeavors to lay the blame at the doorstep of others. In my view, the prosecution proved its case on these counts through the evidence of the witnesses Madulidi and others mentioned in the preceding paragraph. He is found guilty on these counts. Paragraph 37, counts 640 to 641. These counts relate to the creation of child pornography. Several children testified that the accused requested them to make videos of themselves in a naked state. See the evidence of TW paragraph 9 supra, WS paragraph 18 supra, TC paragraph 13 supra, and the accused himself admitted that he asked his kids and in some instances directed them to make these videos. The accused is therefore found guilty on these counts. Paragraph 38 counts 642 to 643 and 644. The accused told the children to make videos so that they could earn some money. These videos were meant for his clients. He instructed and directed them how to make the videos and what they should portray on these videos. In my view, there is an overlapping between counts 642 and 643 and 644. For that reason, he is convicted on counts 642 and 643. He is acquitted on 644. Count 645. This counts relate to facilitating a financial transaction for pornographic videos. The evidence was that the accused requested the children to make these videos for PK and that they would be paid. A 15-year-old boy testified how he received payment for the videos he made. On pages 1341 and 1342 of Exhibit Y, the accused is conversing with PK about sending him videos and negotiating prices for these videos. Accused is convicted on these counts. Paragraph 40, counts 646 to 650 and 732. The accused worked with others such as Herman Kombrink and PK to lure these children by approaching them on Facebook to recruit them to the massage business. In doing so, the children were harbored at the accused's place of residence to perform the sexual acts on his clients for payment. The proceeds received by the boys was shared with him, with the boys and the accused. All the clients on whom the sexual acts were performed were the accused clients, which he arranged. The accused, when he testified, remarked that the boys were over the age of 16 years and that they participated voluntarily. This is a disingenuous argument because he targeted these children and he exploited their vulnerabilities. And most of these children came from troubled homes and poor backgrounds. One or two of them had personal issues and thoughts of suicide ideation, while some of them attempted to harm themselves by means of cutting. The accused took advantage of the emotional state by offering them a place to stay where they could make money. His conversations with PK regarding his strategy to get the boys to come and assuring PK that he's gaining the boys' confidence is testimony to his cunning modus operandi. On count 648, he is convicted of attempted human trafficking of TC. He is convicted on counts 646, 646, which the victims were paid. He is accordingly found guilty on these counts. Count 654. This count relates to the accused having used his premises in Sandringham to conduct a massage business where the victims had to perform lewd acts on his clients, referred to as happy endings. He is found guilty on this count. Count 655. The accused used the premises in Sandringham to harbor, facilitate, and promote human trafficking as the victims, where the victims were housed. The evidence of TW was that they massaged the accused clients and performed happy endings at his premises. During these sessions, the accused would be out of the premises. The appointments for these massages were all arranged between the accused and his clients. The prosecution proved its case against the accused on this count, and he is found guilty. Count, paragraph 45. Count 656. This count relates to the accused unlawful and intentionally publishing, broadcasting, distributing information regarding TW on his device to his clients with a view to securing clients for TW, thereby facilitating trafficking of TW. The evidence tendered by TW in this regard was not denied by the accused. On behalf of the accused, Mr. Albert submitted that this count was established, however, it was a duplication of count 646. I agree with his submission, and for that reason, he is acquitted on this count. Count 657. This count relates to the accused facilitating trafficking TW. In this regard, the accused worked jointly with PK in organizing the transportation and paying for the bus ticket of TW to get to Johannesburg. The whole purpose of getting TW to come to Johannesburg was to sexually exploit TW, who was 15 years old at the time. Mr. Albert submitted that this count was established. However, he submitted that it was a duplication of count 646. I agree with the submission, and for that reason, the accused is acquitted on this count. Paragraph 47. Count 658. This count relates to the accused facilitating the trafficking of SJ. In this regard, the evidence was that it was the accused who arranged the Uber for the child and paid for it. The sole purpose of getting the boy to his home was that the accused would arrange for the boy to service his clients. Mr. Albert submitted this count was established, however, it was a duplication of count 646. I agree with the submission, and for this reason, he is acquitted on this count. Paragraph 48, count 659. No evidence on this count was led in respect of PJTH. Accused is acquitted on this count. Paragraph 49, count 660. This count related to how the accused arranged for DLD to be transported by Uber to his premises for the purposes of the child having to perform sexual acts with his clients. The accused is found guilty on this count. Counts paragraph 50, counts 661 to 663 and 735. These counts relate to how the accused and PK unlawfully and intentionally promoted, aided, recruited, and encouraged each other to commit a Schedule 2 offense. Evidence was led how the accused convinced the parent of SJ, and he used other children to convince the parents to allow their children to go to his place. An example being how the accused convinced PK that he is gaining the boy's confidence and he would eventually come. The accused is convicted on these counts. Paragraph 51, count 664. This count related to how the accused and PK unlawfully and intentionally conspired to commit a Schedule 2 offense. There can be no doubt that the accused and PK conspired to achieve this end. However, in my view, this count is a duplication of count 663. The accused is therefore acquitted on this count. Count 665. This count relates to the rape of SJ by the accused. For details of the rape, see paragraph 12 supra, pages 7, 12, and 13 supra. The accused admitted having sexually penetrated SJ. However, he testified that it was with SJ's consent. SJ specifically testified that he said no, but the accused persisted. Mrs. Dube submitted that the accused's version should be rejected, as he changed his version on how the penetration of SJ took place. Initially, it was put to SJ that when he testified that he had been on top of the accused when he, the accused, inserted his penis into his anus. This changed when he testified and he said that SJ was on the massage table and he got onto him. I will deal under separate heading on how the accused version changed on several material aspects when I deal with the caliber of this evidence. The issue is whether the boy consented to anal penetration or not. On the accused's own version, he was teaching the boy how to massage. The boy was lying on the massage table when the accused mounted him whilst on the bed. On this score, the court finds that the accused's version to be improbable, as the child was on the bed being taught how the accused lying on the bed to be taught by the accused how to be massaged when the anal penetration suddenly occurred. The accused raised the question that the boy lied to his father by telling his father that he was happy at the accused's place. Once that is true, the context must be taken into account. SJ was troubled with his existence of living in a boring and parochial life, and he wanted to get away from his home desperately. See S versus Motsweni, 1985, volume 3, essay 590, capital A at 593 and 4, as well as Dwebu versus S, 2004, 4 all, South Africa, 1 SA. The fact that he lied to his father does not mean that he's not speaking the truth on this score. I reject the accused version that SJ consented to the accused's actions of having penetrated him. The accused foisted himself on the boy, and despite the boy saying no to him, he continued. The accused is convicted of raping SJ. Paragraph 53, count 6, 7. This count related to the accused touching and caressing the naked body of SJ, thereby arousing him whilst teaching him how to perform the massages. This charge has been established, however, it is a duplication in the light of the count 665 is found not guilty on this count. Paragraph 54, count 668. This count relates to the incident where the accused sent SJ to PK. The evidence presented by the state establishes that the accused told PK what acts he could perform on SJ, namely BJ and rimming. On the other hand, the accused's testimony was that his golden rule was no intercourse. If the boys performed any acts apart from happy endings, he was not aware of such acts, and those acts were done without his approval. This version turned out to be a lie, because he was confronted with what appears on pages 1355 to 1357, where PK books SJ and another boy from the accused. PK tells the accused that he wants oral sex and he wants to watch the boys fuck. The accused unlawfully and intentionally encouraged the boys to perform such acts on PK. Then later, encouraged the boys to perform such acts on PK, who also, in one instance, asked the one minor to penetrate the other minor whilst he watched. His version that he was unaware what the boys did is blatantly false. This is once again an example of the accused changing his version. See the closing remarks of paragraph 33 above. He is found guilty on this count. Paragraph 55, count 669. This count relates to where SJ was presented to PK by the accused. According to SJ's testimony, they proceeded to do what they proceeded to do to PK, what the accused instructed them to do. They massaged the naked PK and also performed the happy ending, an act which had the effect to degrade SJ. The accused arranged a meeting between PK and SJ. Accused is found guilty of this count. Paragraph 56. Count 670 and 671. This count related to PK having informed the accused that he wanted SJ and another boy to come to his house. See count 668 above. The boy one of the boys penetrated SJ's anus while PK watched. In my view, this is a duplication of charges. The accused is acquitted on this count. Count 671 is once again closely linked to count 668 and 670, that it would be considered a splitting of charges. He is acquitted on 671. Paragraph 57. Counts 672 to 677. On count 673, the accused was discharged in terms of section 174 of the Criminal Procedure Act. The remaining count deals with the accused who recruited TW with the assistance of PK. TW was 15 years old at the time. The fact that the accused must have known, as TW's identity document was sent to PK. Although this is denied by the accused, the birth certificate was sent in order to purchase a birth certificate. 1. The accused trained TW how to perform the massages, which included him having to fondle his client's private parts. 2. The accused pumped TW to his clients to perform these acts in order to receive payment. The money that the child received was shared with the accused. 3. TW and another boy were ultimately presented to the accused's prized client, PK. The accused presented these boys to PK knowingly, intentionally, and unlawfully assisting PK and his other clients to commit these acts, these lewd acts on TW. 4. The accused denied touching PW's penis, which TW denied. The accused's version on this aspect changed as he stated that a happy ending was vital, but a vital part of the business. And without a happy ending, the business would not survive. The fact that the child was to fondle the accused and other unknown person's private parts was degrading and humiliating to the child. 5. The accused sent TW to PK knowing that the latter was HIV positive. He knew that the possibility existed that PK would want to have anal sex with TW, and despite that possibility, he did not warn him of PW's HIV status. For the aforesaid reasons, the accused is convicted on counts 672, 674, 675, and 678. 58, count 678 to 680, which relates to DLD. DLD was a 16-year-old boy who the accused recruited over a period of time. DLD's family was struggling financially and he wanted to make money. He testified that the accused asked him to remove his clothes, which he did reluctantly, as he was not told that this would happen. The accused touched DLD's penis and masturbated him. The accused inserted his penis into DLD's anus. See paragraph 17, supra, pages 16 to 17, supra for details of this incident. After penetrating DLD, DLD wanted to leave. He called his friend to fetch him, as the accused refused to pay for the Uber. The accused's version was that the penetration was consensual and that DLD fancied him. I do not accept that DLD consented to the act. The irresistible inference is that he did not consent, and the boy's subsequent conduct was that he just wanted to get away from the place. This bolsters DLD's view. Why would the boy be so desperate to get away if he fancied the accused, as the latter testified? The boy left because he was disgusted and shocked. He testified that he endeavored and pretended that the incident never occurred, and he tried to block it from his mind. No evidence was led in respect, The accused is accordingly convicted on counts 6, 7, 8, and 9. Count 681, no evidence was led on this count. The accused is acquitted on this count. Paragraph 60, count 682 to 694. These counts relate to the accused sexually exploiting children for financial and other rewards. The evidence presented during the trial showed how the accused arranged appointments for the boys to service his clients for a fee. The children would charge a fee which a cut thereof was to be given to the accused. These services would be provided in all the instances with the exception of where PK was involved at the accused residence. The accused would use videos which the boys made, excuse me, made for his clients and PK in particular. See conversation between PK and the accused on page 1312, where he sent PK a number of videos. He made the boys available to his clients to perform sexual acts with the victims, which included fellatio, running, and in some instances anal penetration. TW testified how he saw approximately 4 to 5 clients who the accused arranged for him. I am satisfied that the prosecution proved this case on these counts and the accused is found guilty on these counts. Para 61, counts 696 to 698. These counts relate to the accused intentionally and unlawfully living entirely on the rewards, favors, and compensation for commission on sexual acts which the children performed. He also received money from PK for the videos which directed the boys to make. In short, the accused made a living from the labors which the children performed on his clients. It appears that he did nothing other than poking these children for a living. He testified that he conducted a cookie's business. However, none of the children saw him making such delicacies. He is convicted on these counts. Para 62, count 699 to 712, sexual grooming of children. Each of the boys recruited were housed by him. He trained them how to do the massages and he arranged clients for them. He recruited vulnerable children on Facebook and he befriended them in order to gain their confidence and trust. In his own words, he told Kennedy, to be patient, he's gaining the boys' trust. See page 1117 P/2020-0819/WA0039.opus. The accused enticed the minors to come to Johannesburg by offering them a place to live and earn a living. To this end, in some instances he paid for the transportation to Johannesburg with PK's assistance, and other instances for the Uber fees to his place. He spoke to some of the parents who convinced them to send the children, such as in PW's case, and he even lied to the parents, as he did to PW's father, who specifically asked him whether the massaging business entailed any sexual activity, to which the accused replied no. Accused is convicted on these counts. Para 63. Count 713 to 717. Accused exposure of nudity at the Ramaskloof and the swim school. The evidence relating to these charges can be revisited in paragraphs 14 to 16 supra and paragraph 20. His nudity in the public facility at these places was done with the intent that the boys observe him in a sexual act of masturbating, as he had an erection on both occasions, thereby embarrassing the children, causing them to leave the shower room and change room and telling their parents of this indecent exposure. These two incidents were at two different places. However, the similarities in the accused's behavior are pronounced. See S versus Matthews, supra. The accused's version on both these incidents is rejected by the court as being false. I accept the version given by the boys who testified on these counts without reservation as being honest and truthful. He is convicted on these counts. Para 64. Accused and PK together used the victims to create, produce images / videos of child porn. The making of videos at the instance of PK and the accused was not denied. The children were directed to make these nude videos for which they were paid. Apart from the children making videos, a video was found on the accused's hard drive by Mr. Claessens where he penetrated a boy. See page 1238, where PK tells the accused, where PK tells the accused, ideally, the boys should play with each other. At page 1261, message where the accused asks Kennedy, the boy is asking if he must send a butthole picture. Also, he ... The accused is convicted on these counts. Para 65, count 728, malicious damage to property. This count relates to the damage at the Boom Gate at the Sunning Hill Athletic Club. He is convicted on this count. Para 66, count 6, rather 729 to 731. Attempted murder charges. The accused sent several boys to PK well knowing that the latter was HIV positive and that Kennedy had HIV positive. Kennedy had anal sex with a 14-year-old boy, WS, who the accused sent. It was argued that the accused, when he got to know of PK's HIV status, continued to send boys to him. He knowingly sent a 14-year-old boy to PK, who was raped by him. In his evidence in chief, he testified that he was unaware of what happened at Kennedy's place because his golden rule was that there was no intercourse, and where the children consented, they could do so as they were at least 16 years old. This is a blatant lie. As the accused, when one views the exhibit and the album with the SMSs and the conversations between him and Kennedy and his clients take place, it is self-evident that the clients tell him what they want to do with boys, and he promises that he will send them boys. And that his golden rule is nothing other than a figment of his imagination. He advertised the boys in some of the messages that they could be rimmed, and that these boys were prepared to perform fellatio, and that they were even ready to be penetrated. And notwithstanding that, he had the temerity in this court to testify under oath that it was his golden rule that there would be no sex. The accused, I can't put it in stronger words. I have seen people lie, but the manner that he lied in this court under oath is shocking, to say the least. That very little credence, if any, can be placed on his evidence. In the Come Ed's advert, messages to the accused say, and in inverted commas, seeing as you find these guys, I'm looking for one that will fuck me. But thanks for messaging me, the accused responds. Yet his golden rule was no sex. The accused admitted that he had consensual sexual intercourse with SJ and DLD. Both SG and DLD consented to him having intercourse with him. The issue with the DLD consented to sexual sex was dealt with in paragraph 55 supra, and I'm not going to repeat it. Paragraph 67. The accused did not impress the court as a witness. He contradicted himself on numerous aspects. The most notable being that the boys, that they were not to have sex, as that was his golden rule. When he was confronted with the messages between him and Kennedy speaking about the rimming of the boys and one of the boys being a virgin, he had no answer. He initially stated that he did not fix prices. However, he is reported to have told clients 1,200 for one boy and 2,000 for two boys. His version was a denial of all the allegations against him. He denied that he was at the Hamas Kloof in 2007. However, the father of one of the boys grabbed him by the shirt and warned him that if he saw him again the next time, he would call the police. I accept the evidence of DR Senior, who gave evidence in this. He gave evidence. Honestly, the accused was evasive and he did not answer directly. Time and again, questions would have to be repeated. On other occasions, his answers to questions had no bearing to the questions, resulting in the questions being asked again. I can safely say that the accused evidence was so poor and contradictory that it should be rejected, save where it accords with the state's evidence. 69. Count 732, 733, 734, and 735, human trafficking. The defense contended that these counts were established. However, it relates to one continuous transaction. The accused, together with PK, arranged for the boys to come to Johannesburg in order to exploit them sexually so that they could make money from the sexual activities which the accused arranged for the minors. This was a carefully thought out scheme orchestrated by the accused, whereby these victims were exploited by the accused in order for him to get an income and make a living from this trade. He is found guilty on these counts. Para 69, count 736, the charge relates to the rape of WS, a 14-year-old victim. This count relates to PK having had intercourse with the boy. The state submitted that this was done with the approval of the accused who instructed WS to have intercourse with him. The accused denied that he told the boy to be intimate with PK. However, the conversation between PK and the accused on this score is self-evident. They discussed the 14-year-old boy who was coming to the accused soon. The accused is convicted on this count. Count 737, this count relates to sexual exploitation of the children and WS. The accused utilized this child by making available to his client for their sexual needs, and in the process he received a percentage of the fee for which he was paid to the minor. The evidence clearly established that the minor was exploited for sexual acts at the behest of the accused. The accused is found guilty on this count. Count 738. This count pertains to the accused receiving financial reward for sexual activities performed by WS. Once the evidence reflected that this did happen, in my view, this count is closely related to count 737, that is a duplication of charges. The children were sexually exploited for the sole object of receiving a reward. The accused is acquitted in this count. Count 739, sexual exploitation of WS. It may be submitted that this count is a duplication of count 737, however, each time that the child is sent to a different customer, it would be a different count of sexual exploitation. If a child was sent 10 times to 10 clients, it would equate to 10 counts as opposed to the child being exploited once only. The accused is found guilty on this count. Count 740, living from sexual proceeds of a child. The evidence presented during the trial clearly established that the accused made a living from sexual exploitation of children. At one stage, the evidence revealed that he had 7 masseurs working for him at a time. From these activities, he could pay the rental for premises in Senton and had an income to sustain himself. He is convicted on this count. I'm not done yet. Paragraph 69. Paragraph 74 is a paragraph I thought about at great length, and I had ambivalent feelings in whether I should incorporate this paragraph in this judgment. I asked my registrar to, in fact, cut and paste it from my computer onto this judgment, and she omitted to do so. However, I did it this morning, and I will try and paraphrase this, Judge, this what I said intend to say in this paragraph. And this paragraph relates to the role played by PK for Paul Kennedy. One is always averse in wanting to say negative and bad things about somebody who has departed this world. However, I would be remiss in my duty if I were not to say something in this regard, notwithstanding the fact that PK is not here. Paul Kennedy played a vital role in this matter, and he was a participant in many of these crimes. So you got it. I would be remiss in my duties if I were to skirt the role played by him. Mr. Kennedy was a participant in this matter. He financed the transportation of some of the victims from their places of residence to Mr. Ackerman's place. He also financially assisted Mr. Ackerman with his day-to-day expenses when the need arose. He commissioned the accused to get the boys to make pornographic videos of themselves, and he paid for those videos. He was the only client, according to the evidence presented in this court, and where the boys made house calls. And he was the only client to which the boys went to his home. At his home, the boys performed massages with happy endings. In some instances, he wanted them to perform fellatio, and he carried out the act of rimming. In one instance, when there were two boys present at his premises, he insisted that the one boy has anal sex with the other minor, an act of rape at his request, for which they were paid for by him. That he took his life was tragic, but not unexpected. As he brought shame to himself and the profession he represented. As an advocate, he realized that the game was up, and he therefore committed suicide. The court is duty bound to say this so that the victims may get closure insofar as the role played by him in this entire dark episode, which I had the total displeasure to live under for 6 weeks. For me, it certainly wasn't a happy ending. That is the judgment of this court.
Answer, please.
The sentence has no previous conviction.
Thank you. Mr. Alberts.
As the court hears, my lord, I intend taking a psychologist report to try and understand some of the accused thinking and cases. I've done some footwork so far. It's difficult finding somebody who is going to be prepared to get involved in this matter. For that reason, I've discussed with my learned friend that if a psychologist is obtained, that I would apply that the person's identity be kept out of the media. It's just not people. But that is another bridge that I will need to cross when we get there. If I have an immigration trial, which would be easier to convince people to think it is possible. I cannot give the court an exact time frame at this stage. I would request that the matter be postponed for 2 or 3 weeks. That we just know if somebody is going to be available and have a time frame for that reason.
Yes.
That I think it will be important when it comes to sentencing to be focus on circumstances at this stage.
There are some minimum sentences here that's applicable.
Indeed, my lord.
See, Albert, I'm inclined to give you the postponement, but what? Let's assume, maybe I'm now going to be speculating, but even if this person, expert you call, is going to come here and say, well, look, the accused is a fallen angel. How is that going to help? In light of what the accused himself testified here, that he's not guilty, he did nothing wrong. Unless, of course, he completely recants that and he changes his mind. I don't know if you follow what I'm saying.
I hear what your lordship is saying, but I can't just...
No, it's not what you can, you know what I'm saying to you? I don't live on an island or in a desert. Like everybody else, I also watch television. Maybe I shouldn't. And I saw your client announcing to the entire world his innocence and that he will go to a higher authority, which he's entitled to do. He can go to whichever higher authority he wants to go to. I did my job and it ends here. But having said that and having seen him so boisterously suggesting that he's innocent, how is someone going to help him in mitigation? That's a question I'm asking you.
My lord,
Isn't that a sheer waste of time in the context of what happened?
my lord, to be honest, some of his reasoning, I would like an expert to just understand how and why. I don't know if that could be of assistance to the court.
Well, I'll give you that indulgence. But in my view, I can't work out how that's going to help, but maybe the psychologist has got some godlike qualities and maybe be able to change my mind, But let's hear what the state has to say.
My lord, I must say, I do not know what might be, but some of the reasoning does appear.
Yeah, no, well, let's hear what Ms. Dube has to say.
My lord, I agree with the court, and however that the accused consent worker is entitled to...
Yes, well, that's the only reason. That's the only reason. Well, what I find difficult is, you see, if he didn't say this, but he goes on national television, I'm this, and I'm innocent, and I'm going to a higher authority, and all this. So how is that going to impact on sentence? I mean, you're going to argue he showed no remorse.
Exactly.
So,
another concerning factor for the state is the fact that, and this has been brought to my attention by my colleague, is that they've been trying to source psychologists who's willing to embark on this journey, and they've been struggling. So my request is that we do not give a long remand for them to find a psychologist that's willing to do the work that legal aid is asking them to do with the accused person. Because justice must not only be seen to be done, but it must actually be done with the victims in closure.
this sad and tragic matter must come to an end at some
That's
stage.
correct. I know legal aid has been out there searching for a psychologist and hasn't had...
You want to say something?
So can
No.
everyone be sure
Because you're
that-
lifting your hands,
No, no,
or just stretching.
yes.
Okay.
I am in the court's hands now.
My lord, as I said...
What date, Mr. Alberts? I'll grant you the indulgence. What date? But please,
just a provisional date in the...
Mr. I'm not giving you a provisional date. I'm going to give you a date long enough I'll be generous in respect of time. But on the next appearance, you either have your person here or nobody, or we continue. We have to postpone it in 3 weeks' time. You come here and say, no, I didn't get somebody, I need another 6 weeks. I'm going to give you, how much time do you need?
My Lord, I would then suggest at least 2 months, if that is the case. I thought,
No, I'm happy to give you 2 months, but I've told you people this at some stage during the course of the trial in my chambers. That at the end of June I'm going on leave. And I won't be back until very late in the year. If you're happy to live with this, the accused is in custody, it's not my fault.
well, my Lord, 2 months from now would be the 24th June, but that is a Saturday. One would be...
Term ends, I think, on the, I'll give you the date when term ends.
No, that might very well be.
Term ends on the 19th of June. Lisa. Choose a date in the 3rd term, July. Starts 18th July. If you can get a date early in that week that suits you and Mrs. Dube, then it's fine. Because after that I'm going on leave.
My Lord, the 18th then, if that would be acceptable.
I don't know what his duties are going to be allocated to me, but you can tell the role planner and I will inform the DJP and the JP. How many days will you need?
Lord, I suspect that we should at least make it 2 days, but I would suggest maybe 3. I do not know if the report is accepted, it can be handed in and it will be found after the date. I think necessary for the so I would suggest that we then make it 8 that is
Suits you? Mr. Alberts are making it abundantly clear. And I want your client to understand this. This is a lengthy postponement. Let's ignore April. It's got a whole of May, June. It's got 2 months and 2 weeks. It's got 10 weeks. If you're here and there's no report, this matter will go on. If you're not here, because one never knows what happens, and the accused comes and he decides to get a new lawyer, and the new lawyer says, no, I want time for a report, I'm not going to listen to him. As far as the report is concerned, we've agreed upon this. I've given you an indulgence of 10 weeks. If you can't get someone here, a psychologist here in South Africa, import one from the UK or the US. If you ship him or her, they'll be here in a week. Okay. But on the 17th, is that, or the 18th we said?
The 18th.
On the 18th, this case goes on. And I'm not going to speak directly to Mr. Ackerman. Did you understand that?
Yes, my lord.
Whether you have Mr. Alberts, or you have Mr. X, or whoever, I'm not going to entertain a request for a postponement for this. And then you can make whatever comments you want to again to the press. Your case is postponed to the 18th of July this year. You are in custody, you'll be kept in custody. Thank you, you may stand down. What do I do with all these exhibits here? I'm not going to keep them. No one is going to get this.
Yes, of course. Absolutely. That's 12, huh? Yeah.
You'll get your box.
Just want to check one very technical thing. Did you?
I want to check exactly how many of the 12.
Yeah, that's what I'm trying to
Yeah, no, I'm worried about these things here because, you might go to higher authorities, All right, the proof, please.
All right.
Can I quickly just post